Hello students, welcome to another session of Law Optional Simplified. Now today let us understand the provisions with respect to new bills which has been introduced by the government to replace the existing Indian Penal Code, the Criminal Procedure Code and the Indian Evidence Act. Now it's important to understand the purpose of criminal law as we have already discussed this in the previous lecture. As the purpose of any criminal law is to protect the life, limb, and property of its citizens, along with maintenance of law and order. But any law in any given society must keep pace with the changing dynamics of the society, be it political change, socio-economic change, or technological change, or any other change which is taking place in the society. So, these new bills also, in a way, aims to keep pace with the changing dynamics of the society along with decolonizing of these laws, as these laws were written or these laws were enacted during the British time. So the purpose of these laws is mainly to incorporate these changes through, through categorization of these new offenses as a part of the Indian Penal Code or the new Bharatiya Nyaya Sanhita, and also to facilitate speedy trial procedure and scientific collection of evidence. So there is aspect of incorporation of technology because the society is changing at a very dynamic pace. As you know, we are now talking about machine learning and artificial intelligence. So all these aspects, mainly the use and misuse of technology, must be incorporated as a part of our criminal law justice system. So this news highlights that revamp of criminal laws and center brings bills to replace the three laws, namely IPC, CrPC, and Evidence Act. And as of now, these bills have been sent to the Standing Committee on Home Affairs, which will submit its report after 3 months. So, coming to the new bills, the Indian Penal Code will become the Bharatiya Nyaya Sanhita of 2023. The Code of Criminal Procedure will become the Bharatiya Nagrik Suraksha Sanhita of 2023, and the Indian Evidence Act will become the Bharatiya Sakshi Bill of 2023. So these are the new names given to the old laws. Now coming to the purpose of these bills, as I've stated that the main purpose is to keep pace with the changing dynamics of the society along with decolonization of the laws, as these laws, namely the IPC, CrPC, and Evidence Act, have certain colonial terms, and these terms needs to be done away with. Another important purpose is citizen-centric approach, as the purpose of these bills is to ensure justice. And this is also reflected in reorganization or rearrangement of the provisions in the Bharatiya Nyaya Sanhita. It then mentions about speedy completion of trials, and here there also will be done with the aid of technology, and this also will be incorporated with adding new crimes along with change in punishment, as it adds community service as a form of punishment. So overall, these can be said to be some of the purposes of the new bills. So let us understand these purposes one by one. So the first purpose is decolonization of laws. Now, as you can see in the Indian Penal Code, the CrPC, and Evidence Act, there are references to these colonial terms such as Privy Council, Her Majesty's Government. Here in IPC, the definition of British India, although this was repealed way back in 1937, yet it highlights these colonial terms. This illustration from the Indian Evidence Act mentions about a city of Lahore. So all these reflects a colonial mindset, and these mindset needs to be get rid of. As an example of decolonization of laws, the term sedition has been done away with, as even the Supreme Court of India had stayed the term sedition, which has been or which was provided under section 124A of IPC. And new offenses have been added in the Bharatiya Nyaya Sanhita, which will replace the IPC, such as secession, armed rebellion, subversive activities, separatist activities, or activities which endangers sovereignty or unity and integrity of India. So these are some of the examples of decolonization of laws, and the purpose is to get rid of such colonial mindset. Now, another example of decolonization of laws is the way in which the provisions of IPC has been arranged so far. So it talks about abatement criminal conspiracy, then offenses against the state, offenses relating to army, offenses against the public tranquility, offenses against the public servants. So priority has been given to the offenses against the state or offenses against the public servants. Whereas in the Bharatiya Nyaya Sanhita, priority has been given to offenses against crime against women and children, and also offenses affecting the human body, which include serious offenses such as murder, culpable homicide, abduction, slavery and forced labor, etc. So the objective of the Bharatiya Nyaya Samhita is to ensure justice, and as a means of ensuring justice, punishing the wrongful act. So if you look at the Indian Penal Code, then offenses against human body, which includes murder, comes way later, and hence murder has been provided for under section 302 of IPC. And offenses relating to marriage, which is also an example of offenses against marriage, comes much later in the IPC. So the idea is to give offenses against women and children and offenses against or offenses related to human body a priority in the Bharatiya Nyaya Sanhita. Now moving to the second aspect of incorporation of technology. Now the incorporation of technology has been done in order to make all these laws citizen friendly or citizen centric as well. So this clip highlights about the purpose or statement of object and reason of the Bharatiya Nagrik Suraksha Sanhita 2023, which will replace the Criminal Procedure Code. So it says that citizen-centric approach have been adopted for supply of copy of first information report to the victim and to inform them about the progress of investigation, including by digital means. So incorporation of technology for the facilitation or for citizen friendly approach. So it says that this Bharatiya Nagrik Suraksha Sanhita provides for use of technology and forensic sciences in the investigation of crime and furnishing and lodging of information, service of summons, etc. through electronic communication. Similarly, the Bharatiya Saksh Adhiniyam, that is the New Evidence Act, highlights that evidence includes any information given electronically which would permit appearance of witnesses, accused, experts, and victims through electronic means. It then mentions about admissibility of an electronic or digital record as evidence, and it shall have the same legal effect, validity, and enforceability as paper records. So clearly, these are some of the examples of incorporation of technology in the Bharatiya Saksh Adhiniyam, which will replace the Indian Evidence Act. Now, other examples of incorporation of technology includes expansion of the definition of documents to include all types of electronic records, to digitize the entire process of from filing of FIR till that of delivery of judgment. Videography has been made compulsory at the time of search and seizure, and without such videography by the police, no charge sheet shall be valid. So videography will further provide authenticity to the entire investigation process. Constitution of National Forensic Science University by the government, and visit of the forensic team made compulsory at the crime scene, especially for offenses where punishment is 7 years or more. So these are some of the elements of incorporation of technology within the criminal laws. So this reflects the changing dynamics and adoption of those changing dynamics as law will now reflect this changed dynamic of the society, particularly with respect to the advancement in science and technology. Now, another aspect highlighted in these bills is a clear focus on justice delivery mechanism by focusing on women and children. So it mentions about sexual violence cases where it says that statement of the victim shall be made compulsory, and video recording of the statement is also compulsory in case of sexual harassment cases. Further, it criminalizes sexual intercourse if it is done on the basis of false promise of marriage, false promise of employment, and promotion, or false promise of promotion on the basis of false identity. Further, it provides for increased punishment in gang rape cases, as a provision of 20 years of punishment or life imprisonment has been provided for in cases of gang rape. Crime against girls below 18 years, provision of death penalty has been introduced, and punishment for offenses against children has been increased from 7 to 10 years. So laws has been made with a clear focus of justice delivery, especially for offenses against women and children. Another important aspect is early completion of trial, and this has been incorporated in the criminal procedural laws, as it highlights that police will compulsorily give the status of complaint in 90 days and thereafter every 15 days to the complainant, as this will also make police duty bound to provide information to the complainant with respect to the progress made in the investigation. Further, it says that charge sheet needs to be filed within 90 to 180 days. So it sets a time limit within which investigation has to be completed and charge sheet has to be filed by the police. It then says that court bound to give notice of framing of charges to the accused person within 60 days. So certain setting up of a time frame will further speed up the investigation process. Another important aspect highlighted in these laws or in these bills is changes made in punishment. And one of the form of punishment is community service, which has been added in the Bharatiya Nyaya Sanhita. So it says that the punishments to which offenders are liable under the provisions of this Sanhita are death, imprisonment for life, which means imprisonment for remainder of the person's natural life, imprisonment of two descriptions, rigorous, that is with hard labor, and simple imprisonment, forfeiture of property, fine, and community service. So these are the different types of punishments provided under the Bharatiya Nyaya Sanhita. Now these are other changes made in the form of punishments, as it also provides for punishments for mob lynching, which provides all three punishment, namely imprisonment for 7 years, life imprisonment, and death penalty. Then causing permanent disability or brain death is also punishable for imprisonment up to 10 years or life imprisonment. Criminals who run away from custody, such criminals will be imprisoned for 10 years. There is a separation of offenses with respect to grave offenses or offenses causing grave injury and offenses causing minor injury. Earlier, both these type of offenses, the punishment was 7 years. And the provision of community service as a form of punishment has been introduced as a new form of punishment. Now, other changes included in these three new bills are attachment of property of declared offenders, new provision of harsh punishment against interstate gangs and organized crimes, description of terrorist activities and associated punishments. Offenses punishable up to 3 years will be included in the summary trial. So this will also help to reduce the burden of the judiciary. And provision of zero FIR has also been provided for, as this is another citizen friendly approach, as citizens can file FIR from anywhere within the country. So these are some of the changes which has been introduced in these three new bills. So it's important to understand not only the changes but also the purpose as to why the government has introduced these three new bills, which will completely replace IPC, CrPC, and the Evidence Act. And the purpose obviously is to keep pace with the changing dynamics of the society and also to decolonize these laws. Thank you very much.